Hey, loungers. I hope everybody is doing as great as I am today. Listen, guys, I've got a little bit of time this afternoon, so I wanted to go over the new information that just came out on Pacer from TD Jake's camp regarding this Youngblood and his response that he gave to the court the other day, asking for a quote unquote extension. And we are definitely going to get into this because, like I said a few things the other day that I expected to happen from TD Jake's camp, and this is exactly what's going on. So we're going to get into this paperwork now. Steph, I appreciate you being in the building. Shout out to you, and glad that you're here because you can always answer any questions that I may have in regards to this matter as well, and everybody else that's in the clouds. So let's go ahead and get right into it, guys. Make sure you guys are hitting the like button on the way in, and let's go ahead and get started, guys. So today has been a very interesting day in the courts regarding this story with Larry Reid, Youngblood, and TD Jakes. Okay, it's definitely been a crazy day and a crazy weekend in regards to this. And like I said before, I really don't think that Dwayne Youngblood really had some good information that was given to him. Obviously, he has not spoken with an attorney regarding this matter because he definitely tried it with this message that he gave the other day that we went over extensively the other day. And now we're going to go over the response from the actual attorneys of TD Jakes because they did respond to this. Okay, so I'm going to go ahead and share my screen with you guys so that you guys can see for yourselves what is being said. So bear with me just a moment. We are going to take a look at Pacer. And shout out to Pacer. If you don't have an actual Pacer account, you should try to get one because there's a lot of information on there that you're kind of missing when you don't look at the actual court documents themselves, okay? So let's go ahead and share our screen here. And we're going to look at the Pacer case. Let me make sure you guys can see. Okay, so you guys can see that. We're going to look at the actual case. And again, this is the TD Jakes versus Youngblood, where also Larry Reid has been mentioned in this case as well. From the last part that we left off was on the 20th, where Dwayne Youngblood had filed a letter with the court claiming that this wasn't an actual response, but it actually was an actual response, okay? And it looks like the court is deeming it as a response. So it says motion for extension of time to file response reply, okay? So even though they're not saying that yet, this is what the attorneys are actually saying in response to this. So there was a series of things that happened today on the 23rd. One was a brief in opposition to the other. The other is a notice of appearance, another notice of appearance, order on motion for extension of time to reply, which we're going to take a look at, and then the response briefing schedule, okay? So let's go ahead and take a look at the motion that was entered. Well, we looked at the motion for the time to reply that was entered on the 20th. And now we're going to look at the brief in opposition to that response. Okay, so let's take a look at that real quick. We're going to view that selected. I did download it, but I'm just going to go ahead and just view it for the sake of time. And again, shout out to you guys for following this story and following me. Definitely appreciate you guys and your support of me regarding this matter. All right, so let's take a look at this, okay? So this is in the United States District Court for the Western District of Pennsylvania. Let me go ahead and enlarge it for you guys so you guys can see too. For Thomas Dexter Jakes versus Dwayne Youngblood, John Doe's 1 through 10, okay? And we know that Larry Reid has also been included in this case along with his podcast as well, the Larry Reid Live Show. And this is the case number. This is the opposition to Dwayne Youngblood's application for extension of time to respond to the complaint and motion to strike pursuant to FRCP Rule 12F. Plaintiff Thomas Dexter Jakes, hereinafter plaintiff of Bishop Jakes, by and through his undersigned counsel, files this opposition to defendant Youngblood's application for an extension of time to respond to the complaint in this case and makes motion to strike scandalous and absolutely false material pursuant to FRCP Rule 12. Simply, the defendant Youngblood's submission to the court by letter dated December 20th, 2024, which is the letter we went over the other day, hereinafter the response constitutes a responsive pleading as construed by the federal rules of civil procedure and should be deemed such. Defendant Youngblood's 11th hour application based on a purported need for additional time is nothing more than a delay tactic to further coordinate with his co-conspirators by creating a mechanism to avoid dealing with plaintiff's motion for expedited discovery, ECF document number 14, okay? So there is that document in here, which is document number 14, which is what they're referring to. And as a general matter, move forward with this case and to improperly lob salacious, false, and irrelevant material at the plaintiff. For the reason described below and supported by the declaration of attorney Daryl Janey, this delay tactic should not be countenanced. One, these are the relevant factual and procedural backgrounds. As this court is aware, the complaint in this case was filed on November 25th, 2024. Counsel for plaintiff made a couple of attempts to coordinate service of the complaint and related papers on defendant Youngblood with the person then purporting to be defendant Youngblood's attorney or counsel, attorney Tyrone Blackburn. And then there is a document numbers 1, 3, and 8 that is also listed on the file for the courts, okay? Even though counsel for plaintiff ordered defendant Youngblood an opportunity to waive service, which in turn would have permitted him 60 days to respond to the complaint, defendant Youngblood responded, "Chase me if you dare." Okay, that was what defendant Youngblood said at first. Okay, "Chase me if you dare." We had Tyrone Blackburn saying, "Kick rocks," or was it pound sand, and all this other stuff, right? They talking big trash to these people. Okay, and then he says defendant first rejected that offer on November 25th, and then again doubling down on his antics when counsel for plaintiff iterated its offer on December 4th. Ultimately, plaintiff was able to achieve service on defendant Youngblood on December 4th, more than a week after filing the complaint and following successive requests to coordinate that would have given the defendant more time, 60 days to be exact, okay? Now, by and through his gamemanship, defendant Youngblood failed to obtain the time he now seeks. We submit that defendant Youngblood should not be rewarded now for his brazen and apparent arrogance. Now, prior to successfully serving defendant Youngblood directly, counsel for plaintiff received several emails from defendant Youngblood's counsel on December 4th. Those emails articulated a plan to, among other things, file an anti-SLAPP motion against plaintiff and secure affidavits under penalty of perjury to be used against Bishop Jakes. Now, Janey, which declares on Declaration 7, the plan described in counsel's December 4th emails in sum and substance are no different than what defendant Youngblood describes in his response to the court and in his current submission. On information and belief, even though defendant Youngblood describes his status as pro se, attorney Blackburn continues to work with and advise him as counsel. In part, we submit that is the reason defendant Youngblood carefully states that he is in the process of attempting to retain local counsel. Now, they do have a response in regards to attorney Blackburn in here. We're going to look at that exhibit in just a moment. But that exhibit is basically explaining that attorney Blackburn is under some type of grievance that was filed by this particular court due to improper conduct, okay? And we're going to take a look at that in just a second, which may be the reason why Blackburn is not attempting to represent Youngblood in this situation, because he knows he cannot get clearance within this court, okay? And we're going to take a look at that in just a moment. Now, he says, now you can see the response on 1 and emphasis is added, where he's talking about the process of obtaining local counsel. Now, the issue is not that defendant Youngblood suffers the need for counsel, rather on information and belief that defendant is facing a two-pronged problem. The first one, on information and belief that Attorney Blackburn is having difficulty getting sponsored by local counsel to support him for admission in the Western District of Pennsylvania, given admonishment by federal district court judges in response to counsel's conduct. Okay? Now we're going to look at the exhibit example in just a moment. For example, on April 3rd, 2024, Judge Denise Coate, District Court Judge in the Southern District of New York, referred Anthony Blackburn to the Grievance Committee of the Southern District of New York, issued an opinion and order stating a reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressures defendants to settle quickly. Indeed, his submissions to this court have been rife with disturbing allegations against the defendants and counsel. So we'll take a look at that in just a moment. The second one is on December 17th, 2024. Plaintiff filed a motion for expedited discovery requesting approval from this court to issue 2 third-party subpoenas, which in turn are anticipated to reveal identities of John Does in this case and further substantiate plaintiff's conspiracy claim. By December 18, 2024, based on assertions by defendant's brother, Richard Youngblood, on a podcast, defendant Youngblood was working tediously to provide his response to the court to the allegations made in the complaint, and that the public could expect that answer within the next week as the deadline, December 26th, is approaching. And we have that argument as well, where the brother guys had went live on his show and talked about this whole thing and claimed that Youngblood would be ready for a response by the 26th, okay? So he's got so far Blackburn speaking for him and his brother speaking for him, and neither one of them can kind of lean up to what Youngblood really actually is willing and able to do, okay? Now, here's the argument. Argument A is defendant Youngblood's December 20th, 2024 letter, which is on document number 17, is a responsive responsive pleading to the complaint and should be deemed as such, okay? And this is what they said for why. Now, defendant Youngblood's response constitutes a responsive pleading within the meaning of Federal Rule of Civil Procedure 7A, because it engages with the substantive issues raised in the complaint and responds to the merits. It is no mere request for an extension of time to secure legal counsel. So, see, if he had just simply said in the letter, I need more time to secure counsel, and left it at that, perhaps he may have had a bit of an argument. But it's the fact that he decided to go into detail about what was said, throw this anti-slap motion into there as if that really applies, and then also threw pictures in, put up additional salacious stories in regards to how people are disappearing, from going against TD Jakes and so forth and so on. So technically, yeah, this is an actual response to the complaint, okay? So let's go ahead and keep going. It says, it is no mere request for an extension of time to secure legal counsel, but rather first, defendant Youngblood specifically argues that Bishop Jakes' complaint is without merit, and then he proceeds to identify affirmative defenses to the complaint itself. Specifically, in pertinent part, he states, Your Honor, I have unwavering confidence that the court will discern the lack of merit in the plaintiff's claims, which I firmly believe constitute a violation of my First Amendment rights. That was number one response. Then he does not provide a mere conclusatory assertion. Rather, the defendant cites and elaborates on case law in support of his protected speech defense, including a New York Times versus Sullivan response too. Okay, now remember that. Remember he had the New York Times. He was talking about Hustler magazine. There was a couple of things he had said in regards to this, right? Now, so he used case law as well. Now, this is clearly an effort to provide notice of his intended defense and the basis in law for his argument. Here, in this respect, defendant Youngblood and his counsel is trying to comport with FRCP Rule 8 by articulating affirmative defenses as to the reasons Bishop Jakes should not win. Okay, so he actually put up actual arguments and defenses in regards to why TD Jakes should not win this case. Okay, so this is clearly a response to this complainant. Okay, now in addition to his protected speech defense, defendant Youngblood raises the specter of affidavits in support of his quote-unquote truth defense to the libel claim. Now, further in his 6-page submission, defendant Youngblood articulates and elaborates upon the reason he should fall within a heightened protection under the First Amendment, because Bishop Jakes is a public figure. Moreover, he raises the affirmative defense of waiver in accordance with FRCP Rule 8. For example, defendant Youngblood states, despite my consistent and public recounting of these incidents, Mr. Jakes did not see fit to file a defamation lawsuit against me during any of those years. This inaction suggests that Mr. Jakes himself recognized the validity of my statements or deemed them unworthy of legal challenge at the time. Response 2. Now, again, this sort of elaboration and detailed reply, while erroneous and ineffectual in this case, is in fact the nature and substance of a responsive pleading. Now, given that defendant Youngblood has submitted an answer to the complaint, the clock should not stop on the procedural mechanisms that then follow under FRCP in order to move this case forward. For example, we submit that Rule 26F initial conference should proceed, and whatever motions defendant Youngblood intends to bring can be discussed with the court at that time without prejudicing the plaintiff by, in effect, postponing the day of reckoning for likely 30 to 60 days. The defendant Youngblood, and this is the B part of it, defendant Youngblood's shameful assertion that Bishop Jakes is responsible for murders should be stricken. Defendant Youngblood states, upon information and belief, Bishop Jakes and his family have a reputation of having individuals who challenge them or expose their dirty dealings disappear throughout the years. And then he has the response to. This statement can only be characterized as an allegation that plaintiff has been engaged in violent criminal activity, including murders or M-words, okay? This should be stricken pursuant to FRCP Rule 12. Rule 12 permits courts to strike any insufficient defense or any redundant, immaterial, impertinent, or scandalous matter in a pleading, including an answer. Thomas v. Keystone Real Estate Corp Group, and then he gave the case law for this. Now, such motions are granted where the allegations have no possible relation to the controversy and may cause prejudice to one of the parties. So, and then he gave some more case law on that. And then he says, here, the bold-faced lie that Bishop Jakes has participated in making people, quote unquote, disappear is scandalous, and at its core, it has no relation to the libel and conspiracy claim in this case whatsoever. And we did go over Rule 12 the other day in regards to this when we were talking about the Jay-Z thing. So I believe this would in fact apply here too. So yes, it does look like, in fact, you cannot just go in and give salacious comments, even in statements. You cannot just go in and give salacious comments in responses in courts, and you can in fact be held liable for these things. So in conclusion, defendant Youngblood's application in reality is a Trojan horse simply intended to undermine the litigation process in this case. If permitted, the application would result in substantial prejudice to the plaintiff for the reasons described herein, above, and within the supporting declaration. Accordingly, we submit that the application should be denied. And then this is right here, just one of the footnotes that says defendant Youngblood also produces a screenshot of a message from Jermaine Jakes from November 3rd, 2024. Plaintiff makes reservation to more fully address this absurd accusation by defendant at a later time. In the instant moment, it is worthwhile to comment that this purported text was never mentioned in defendant Youngblood's extortion letter on November 15th, demanding $6 million, okay? So And this comes from the actual attorneys. And this is just his declaration being sworn that he is the attorney on this case and what the facts are of this case. And this right here, they did present as Exhibit A, which shows where there is an actual opinion and order that was given by a Southern District of New York attorney against Tyrone Blackburn. Okay. And what this was all about and how they filed this action against him and why they believe he is, kind of like kind of acting funny and acting in limbo and pretending that he doesn't understand what's going on and he don't really got anything to do with this and so forth and so on. But it's not hard to know about Blackburn and how many times he's been involved with some very salacious stories, even with the T.I. and Tiny story and how that story has now changed, how even the person who originally was accusing them of this has recanted their story. And there's been a lot of other things that have happened with that particular situation. And that situation just kind of went away on its own. And then this just kind of lists multiple other conversations and stories that Tyrone Blackburn has been involved with and what they presented to the court as to him and why he should not be considered, this man's a decent attorney for this man. Okay. So let's go ahead and go back again. We read all that. So now we're going to go ahead and take a look at these other comments here. Hey, Teresa, appreciate you being in the building as well. Let's go ahead and take a look at this response to this, okay? Because there was a response that was filed as well. So we got the order on motion for extension. Let me look at that and see what happened with that real quick. Okay, so it says order granting motion 17 motion for extension of time to file responsive pleading due on, okay, so 1/23/25. No further extensions of time will be granted. And then, so William Stickman did in fact give him a time to respond. So by January 23rd, 2025, Youngblood has, and Larry Reid and them, they can respond in regards to this. So maybe Larry Reid will finally give this man some money to actually respond to this and respond properly to this and give, a proper response to this. But we will have to see what actually happens with that. And here is the scheduling order. So the response to motion 14 to expedite discovery is due by January 6th, and that has been signed off by him as well. So he is allowing the expedited discovery due on January 6th, but he is also allowing Youngblood to respond by January 23rd. So which one of y'all is going to give Youngblood some money to come up with to fight this matter? I mean, I don't know how many people are willing to do that at this time. Hey, Make a Change, appreciate you being in the building. I don't know how many people are willing to actually give him some money on this, but it seems like the main person that would want to help him with this matter would be Larry Reid himself, right? Considering the fact that he's the one that had him on the show, okay? He is the one that was encouraging this behavior from him to begin with, okay? And so now, it seems like he would go ahead and provide some cash funds to his friend here, in order to secure a decent attorney that would be willing to fight this matter, okay? But we're going to see what actually happens here. But it looks like Jakes and them are turning up the heat. They are not playing around. Even though they didn't think that he deserved it, the judge obviously signed off on it and did allow for Youngblood a significant another month or so to respond to this. So you guys let me know what y'all think in the comments regarding that. I'm going to tell y'all what I believe now. I believe that the judge was trying to be fair, right? I think he knows that this Youngblood guy clearly does not have the funds that it would take to go up against such a, such a powerhouse as TD Jakes, okay? And so I think he's trying to be as fair as possible. I think he's trying to do his best not to allow this man to be railroaded and to just kind of have this preponderous, ability to overtake this man. I think he's doing the best he can to make sure that that doesn't happen. And so, he's going to go ahead and give him till the 23rd. Now, do I think that Youngblood is going to get an attorney by the 23rd? Well, if Larry Reid doesn't pay for it, no, I really don't think so. Like honestly, I don't think he's going to come up with the money at all. If he wasn't able to come up with the money by now, I don't know what 30 days is going to do, right? But this obviously is a very fair a very fair judge in this matter, which is a good thing. And I think by the end of it all, we're going to see what actually fully and physically happens with the whole situation. But ultimately speaking, I do think that Jake's and well, not Jake's, but definitely Youngblood and Larry Reid are in hot water. Okay. Now, what I do think is Larry Reid may have a little bit more means of paying his way up out of here. Okay. Maybe, well, from what I understand, him and Bernard Jordan aren't even really fooling with each other like that. But if in the event that, they still are, I could see Bernard Jordan trying to help him a little bit more with this, pay for this a little bit more. But as far as Youngblood, I think he on his own. I mean, I really think he on his own here. I don't think anybody is going to pay for this. I think the Tyrone Blackburn guy, he just doesn't have the ability to fight back in these courts. I don't think he, based off of the complaints that have come through about him, I don't think he will have be granted the ability to, to go against him in these courts. And I think that's the issue that he's facing, and that's what they've shown to the court. So we'll see what definitely happens with that. But again, y'all let me know what y'all think, and I appreciate y'all for being in today. Make sure y'all hit the like button on the way out, and I will talk to y'all soon. Peace, guys, and thank y'all for watching.